The Constitutional Court will today hand down judgment in a case that will have important implications for freedom of speech. It involves the late former ambassador and radio personality, Jon Qwelane, whose 2008 article in the now defunct Sunday Sun compared homosexuality to bestiality. In 2017, he was ordered to apologize when the Equality Court and the High Court found him guilty, but he appealed at the Supreme Court of Appeal. It agreed with him and ruled that Section 10 of the Act was unconstitutional as it goes against freedom of speech. Legal analyst at the International Commission of Jurists, Tanveer Jeewa, joins us now for a preview of what to expect in the Constitutional Court. Tanveer, it's great to have you with us on the show this morning on a case that is some 13 years in the making. Why has it taken us this long to get here?
Thank you so much, Michelle, for having me today. I think importantly, I've heard a lot of conversations about the Constitutional Court taking longer, and I think a lot of people are misconstruing the fact that maybe the Constitutional Court added to this amount of weight. While it definitely did, because they heard the case last year in 2020, I do think that the 13 years delay has more to do with really the efficiency of all our courts and our judicial system. So it's not really to be pinned on a single thing, but it really gets us to think about, the efficiency of our judicial system broadly. But I don't think it necessarily should be pinned on the Constitutional Court itself, while it did take longer than it usually would for other judgments.
As we know, Jon Qwelane passing away, I believe, in 2020. The merits of the case, though, despite his passing, still stand. It's this issue of the right to dignity trumping the freedom trumping freedom of expression, essentially.
Absolutely. I mean, there were a lot of conversations about whether his passing would cause the issue to be what they say moot, which is to mean that the case wouldn't have an impact anymore. But I think it's very interesting that people should say that, because at the end of the day, the main nub of the issue, like you mentioned, was the fact that the Equality Act, also known as PAPUDA, is possibly unconstitutional based on the Supreme Court of Appeal's judgment. And as you mentioned, the right to dignity, especially of LGBTI persons, are a very, very important thing. So this is why this case is still very important, despite the passing of the late former ambassador.
So in your mind, in terms of the arguments that have been brought forward at the Constitutional Court, what are the big arguments from the side of Jon Qwelane around why it's so important that freedom of speech be broadened in this way?
Look, I think the applicants are making good points, because we all agree that freedom of speech is very important. It's a cornerstone of every democratic country, really. So I don't think people who are arguing against or do not support the late former ambassador are against freedom of speech, because we all agree that it's very important. The arguments that they're making, late former ambassador, is mostly that the Equality Act, the provision on hate speech, is too broad and it's not constitutional because it doesn't fall under Section 16(2) of the Constitution, which is quite narrow. But the issue with that is their construction then and their interpretation of what would be constitutional might not encompass a lot of categories of people who definitely need to fall under that category. Because especially if we look at the recent murders, the homophobic murders that have been happening in South Africa, a lot of that is incited by hate speech.
So if, let's say, the Constitutional Court agrees today with the Supreme Court of Appeal in that Section 10 of the Equality Act is indeed unconstitutional and goes against freedom of speech, what happens then?
So this is a bit of a tricky one, because usually what would happen is if a section is found to be unconstitutional, you cannot be found guilty under that section, because it's quite logical in the sense that if the law itself is not good law, you shouldn't be able to fall guilty under that good law. So now there could be other ways of possibly finding late former ambassador guilty, but there would be some loopholes and some obstacles that the Constitutional Court might have to jump through. And I think then we start asking ourselves other questions. But the one thing that I can tell you is that it is possible that they will not find the section to be unconstitutional, but rather will then find the current understanding of the section to be unconstitutional, and they will explain another reading of the section.
So not the law itself, but the reading of the law.
Something like that, yes. I know it might sound a bit confusing to a lot of people who haven't necessarily studied this, in depth, but it's something like, it's not necessarily the text that needs to be rewritten, but it's just the way we understand the text.
Because that was my next question to you. If the court does agree, as I said, with the Supreme Court of Appeal, what happens to the Equality Act itself if then this Section 10 of the Act is unconstitutional?
So usually the way the process goes, if the Constitutional Court finds legislation to be unconstitutional, is they will give some time to Parliament to relook at the Act and redraft the relevant section that's unconstitutional, and then in the meantime explain or give a substituted reading, if that makes sense. So tell them that in the meantime, until Parliament and the legislature can change the drafting of this act, this is how we're supposed to read it. Although, like I mentioned earlier, it could possibly be that it's not sent back to Parliament and we are given this substituted reading to have instead.
So essentially other cases that are before the country's courts will still have a basis in law to argue one way or the other?
Yes, interestingly, I think I'm glad you asked this question, because I think a lot of us know that there's the case of Masuku, that was also in front of the Constitutional Court, that also pins on hate speech. So even if it's found to be unconstitutional, all the cases that happened before this section was found to be unconstitutional still very much stand in front of the court and still need to be judged on that previous reading of the section.
It's incredibly interesting indeed, and it'll be interesting to hear what the Constitutional Court does decide when it hands down judgment today. She's legal analyst at the International Commission of Jurists, Tanveer Jeewa, joining us for a preview there of what to expect in the country's apex court today. That case, 13 years in the making.